Okay, I think we are ready. Thank you for those who have participated in this important event. On behalf of the entire Latin American practice group, IP practice group, I thank you for your participation to this webinar. We have devoted a number of hours to organize this event, so I thank you so much for your participation. And we invite you all to actively participate. Even though this is, yes, a presentation, I invite you all to participate through questions. Some housekeeping items. The session is being recorded and materials will be shared with you post after the event, obviously. Please use a question and answer function at the bottom of your screen to submit your questions, even though questions will be addressed at the end of the session, but if we don't have enough time, we will send your responses after the session. This is kind of what the agenda that we have prepared for you. And let me give you a brief introduction, thanking you for your participation. And well, what gathers us today is a vibrant topic of industrial designs, how to protect them and how to enforce them in the Latin American region. We must recognize, obviously, that there are different laws and each country has its own legislation about industrial designs. But the important thing here is that we at Baker have experts in each jurisdiction that can help you navigate the diverse laws and interpretation on this very, very specialized topic. In this presentation, we have invited three specialists, and I can tell you that they are really specialists and will give you a general view on different ways of protecting designs, references to international treaties, how substantive examinations are done, extent of the protection, how can be protected, and best practices to develop enforcement strategies. Sometimes it is difficult to determine whether we should protect or sought protection through a design or a 3D trademark or even through copyrights. But regardless of the decision, the conclusion is that for the region, you must always be protected. You must always have a registration. There are many examples of unprotected designs that is impossible to enforce unless you invest a significant amount of time and money in complex litigations. I am thinking about complex litigations involving unfair competition actions. So it's essential that you try to always seek protection. That's why it is important to have this general overview of how to protect and enforce industrial designs. These are the presenters. I also thank Marcela, Valentina, and Marina for the time in their presentations, because they have gathered all the information about the region, and they have made a tremendous job in obtaining important information so that it can be a truly helpful webinar for you guys participating in this webinar. So let me introduce you to Marcela Trego, partner at Trench Rossi in Brazil, Valentina Venturelli, partner in the Santiago office in Chile, and Marina Hurtado, partner in the Mexico office at Baker McKenzie. Let's go to the next slide, please. So we have a polling question for you. A very quick one, and I ask you to please participate. And the question is very easy. Does your organization actively pursue registered designs on the Latin American countries? I will give you just a couple of seconds to respond. It's a very easy question. And I will ask our technical team to let us know when I think we are ready to show the results. Okay, it's important to see that half of the participants do register their designs in Latin America, and that's very important. And an important percentage use other forms of protection, such as copyrights, trademarks. I should understand 3D trademarks, but this is very illustrative. Thank you for your responses, and let's go to the other slide, please. So I leave it up to Marina to begin the presentation. Again, asking you to please feel free to let us know if you have any comments, any questions. You can use the chat function, and we will be more than happy to respond them today, or if it is needed afterwards through email. Thank you so much. And Marina, please go ahead.
Thank you very much for the introduction, Juan Pablo, and thank you all of you to joining us today. We are very happy to present you a very interesting topic about the protection and defense of designs. So to start, the first question is what can be protected and how can be protected? So there are different intellectual property figures that we can use to protect the shape or the ornamental features of our products, or to protect, for example, a set of products like the examples that are there, to protect graphical interfaces, to protect design webs, parts of products, and three-dimensional shapes in general. So the IP right that can be used to protect our designs can vary from country to country as well, of the requirements that have to be met. But as a general rule, I can tell you that, for example, we can protect our designs through international, through industrial designs. So industrial designs, which is the topic of today, normally cover industrial drawings that can be like a combination of lines, color, or figures that are incorporated into a product for ornamental purposes, but also can cover industrial models that are three-dimensional shapes that serves as a pattern to manufacture products, as long as they protect ornamental features and no technical effects. So it's very interesting because in some countries, you need a prior registration of your industrial designs to get protections, but other countries allow for unregistered designs. So we have to know in which country is possible each option. But one of the main requirements to protect industrial designs is novelty. So for example, if you have a product that has been in the market for maybe 1 or 2 years, so it may be not possible to get protection through industrial design, especially for those countries in which you need a registration or where there is substantive examination. So in those cases, for example, you can use another kind of protection like trademarks, for example, as Juan Pablo mentioned. So you can protect maybe three-dimensional trademarks, or for those countries that allow for non-traditional trademarks like Mexico, for example, you can protect your product like a trade dress. And the advantage of use trademarks is that if you meet the requirements, you can renew the trademark forever, no? And that's a very useful tool. Another option will be copyrights, for example, that, as you know, copyrights protect literally and artistic works. It protects mainly the originality of the products. So in many countries, especially those that are members of the Berne Convention, you don't need a registration. However, you can voluntarily register your copyrights, and it's very useful to show the ownership and also to defend your copyrights in the court. The problem with copyrights is that sometimes you may have or you may face problems with authority that may consider that your design or your product maybe is not an artistic work, no? But it's an option. And finally, we have also another options to protect your design, which is unfair competition. For example, that is a possibility in Brazil and other countries. So although there are many international agreements that set general rules to protect industrial designs, there are important differences in each of the countries. So today we will discuss about these differences on the protection and defense of industrial designs. So the next one, please. So before going into detail in this, I just want to briefly mention that the Hague Convention for International Protection of Designs allow for the protection of a design in more than 70 member states and organizations with a single application. So a single application can cover more than 100 designs with a single payment, and also in one language. So it's a very useful tool for companies. So Mexico is the only country in LATAM that is member since June 2020. So it's important for you to know it's a very important tool. However, it's very important to see the declaration of the accessions that Mexico made, because maybe it's not the best option for you. For example, in Mexico, we don't have deferment of publication. So in case you don't want to disclose your product soon, so maybe this is not a good option. Another issue here is the unity of design that we have in Mexico. We have a lot of restrictions. So maybe it's possible that even though you file 100 designs, you have to divide in Mexico into different designs. Another also will be timing. For example, we have companies that have filed several designs designated in Mexico. And even though it has been in place for more than 1.5 years, it hasn't been granted any international design, while you can obtain maybe protection in less time if you file a national application. So it's important to see all the requirements. And finally, it's also important to take care of the priority rights timing and disclosures, especially if you want to protect your design also in LATAM, as will be discussed by my partner, Marcela Trigo, in the following slides.
Thank you very much, Marina. So you're right. When we are talking about industrial designs in Latin America, we have to be extra careful, especially because most countries except Mexico, as Marina pointed out, are members of Hague, and we have different terms for priority and grace periods. We also have different terms for protection itself, and this slide is just gathering the different terms of protection. So we have from 5 years to 15 years under the new law in Chile, and designs can be renewed in some countries up to 3 times, 4 times, 2 times, depending on the country. Next slide, please. And in terms of priorities and grace period, as I was mentioning, this is the difference. We have some countries where the grace period term is 6 months. For instance, Argentina and Venezuela and others. And we have countries like Brazil where it's almost 6 months, but it's not 6 months. And you have to be extra careful because that can be 2, 3, sometimes 4 days before the 6-month period, which you have scheduled for other countries. There's also something to bear in mind, which is priority and grace periods are different things. Priority rights are the right to really claim priority from a prior filing without losing your novelty, whereas grace period is the term that you have that the inventor can disclose or can be other disclosures without defeating your novelty. So you have to bear in mind that in some countries like Mexico, these terms are different. And in some countries, like for instance, Chile, they are the same. Brazil, they are the same. I think next slide, please. Now, a very interesting part of designs, different from patents. In the designs, we have 2 types of systems. Most countries will have a registration system, which means that you file, you fill in the formal requirements, and you get it. And in some countries, you actually have substantial examination like you have on the patent system, where an examiner will look at your design and see whether the requirements are met. As Marina mentioned, in most countries in Latin America, I would say all the countries, the requirements for design are very, very similar. So the designs need to be new, needs to have a distinct shape or form. It needs to fit the industrial application requirements. That means it needs to be replicated without deviation. And finally, it cannot be mandated by functional needs. So this is a very important point and a distinctive feature between a utility model and a patent and a design. If that shape or format or ornamental point is dictated solely by a functional need for that product, you cannot have your design. Going back to the two systems, normally there will be no difference in terms of enforcement on a registration vis-a-vis examination system. But I just learned recently that a new law is coming up in Chile, which may be enforced in January, which although changes the system from a purely examination system to a registration system, it only allows you to enforce your design rights if you actually request examination. Otherwise, you have like an empty design rights where you have a registration, but if you need, you can't enforce. And this is quite different than Brazil, where the law says very explicitly that when you file your design, you already file and have an automatic grant without the examination, you already have proprietary rights. Of course, the PTO can launch an ex officio invalidity case within some term, it's 6 months basically, and suspend your design rights if the PTO itself believes the requirements were not met. Third parties can also launch administrative nullity requests within 5 years from filing, and of course, before federal court during the whole term of the design. But as soon as you file and get it, you are already allowed to enforce those rights and be afforded with the different remedies that Brazilian law will allow. So as you say, we have a region with several similarities, but also different systems and features in terms of design law. Next slide, please. This slide summarizes the time to get an industrial design in the different countries, and you see that it varies a lot as well. The Chile statistics may change pretty soon with the new law coming up in January, but currently is the longer time frame to have a design granted, whereas Argentina, Brazil, they are pretty fast. And then we have Colombia, Mexico, and Peru with similar timeframes, although you would have the Mexican model similar to Chile. They seem to be pretty faster. Next slide, please. And this slide summarizes some requirements, especially formal requirements on how to apply for a design. I will not go into detail because there are several requirements in each law. For instance, in Brazil, you can file only for a single object. Each design needs to fit on a single object, but you can have at up to 20 variations. In other countries, you may have more. In Argentina, for instance, you can have up to 50 examples. So there are different details, but I think what I want to convey with this slide is that you will need someone to take a look at that. Unfortunately, it's not a unified system. You have different rules, different practices. Sometimes you have a manual, for instance, in Brazil, besides the law, which is pretty generic. You have a manual for designs, and there you can find specific details. For instance, Brazil doesn't allow dashed lines, and we have other things that I could mention that are pretty specific to Brazilian practice. And you can see that you have other specificities depending on the country. So my advice here with this slide is you really need someone in each country looking at your filings to make sure they formally comply with the law. And I want to make a very clear point about even in the countries where you have automatic registration, you still need to fit the formal requirements. One thing is the substantial examination, which has to do with novelty, distinctiveness, etc. And this you may be not passing through in all countries. But another thing, which is completely different, is the formal requirements. If you have your claims correctly written, if you have your drawings according to the practice, if you have your written description correctly, how is your description, etc. So in Brazil and other countries, this formal examination will happen even though substantial examination would not. And you can still have office actions, you can still have appeals in the administrative level, only dealing with formal requirements. So you really have to take a look at that. I think that's my final slide. And with that, I'll pass the word to Valentina to keep going with the presentation. Thank you.
Thank you, Marcela. And thank you everybody for joining us today. So as we saw in the previous slides, it's very important to obtain registration for designs. And it's something that we encourage our clients to do to assure protection. But what happens if we did not obtain registration for our design developments and we are facing an infringement? In Latin America, we have seen different strategies in which holders of rights have tried to stop a design infringement, adapting to some possibilities that the law presents in those cases where no design has been registered. First of all, it might be possible to explore the alternative of seeking protection through copyright law, considering that a design is also a creation of the human mind, and as such, it could be covered by the intellectual property law. Some countries have the possibility of filing 3D trademarks, and as such, designs could be enforced through them. But what happens when 3D trademarks are not available? Another option would be filing a claim based in unfair competition, in those cases where the infringer is trying to divert customers and confuse them using a similar or an identical design. Another option that we have seen in Latin America is trade dress, particularly in Brazil, for example. Next slide, please. So given that the protection of an unregistered design through other paths is somehow uncertain, as I said recently, we recommend our clients to obtain proper protection for designs, given all the difficulties that intending the protection through other means could entail. In this slide, we show an overview of different measures that are available in each Latin American country once facing an infringement of designs and once deciding to initiate litigation. We will talk in more detail of each point in the next slides. As you can see, preliminary injunctions are available in all jurisdictions. Generally speaking, they seek to impede a certain action, in this case, for example, to cease the infringement. Seizure of the products is also available in all countries. As to custom actions, these are border measures that seek to prevent the importation of an infringing industrial designs and the entry of the same to the country. In some countries of the region, as you can see, they are not available for designs, but only for trademarks or for copyrights, especially given all the practical difficulties that customs may have in detecting an infringement. In the case of Colombia, especially, the protection through custom measures is available through the criminal law. This particular situation will be addressed in a further slide. Another thing that should be considered is damages. In Latin America, statutory damages are not available, and thus there is a burden for the plaintiff to prove actual damages, which might be a difficulty. In Chile, particularly, as the law will change, a new possibility of establishing damages will be considered in the law, and this will also be addressed in the next slides. Finally, another problem that our countries may face is the lack of specialized courts in all the countries. So this might be or not the most appropriate venue to discuss infringement of rights, because in most of the countries, just ordinary courts will hear infringement of the industrial rights. Just to name a few examples, for example, in Colombia, it could be possible to request as a preliminary injunction the cease of the infringement, the withdrawal from commercial channels of the infringed products, the suspension of imports or exports, the closure of establishments, among others. And as to seizures, it is important that it has to be possible to prove that you are the title holder, that there is an existing right, that you have a certification, and you have to provide evidence that infringement has been committed or is imminent. Next slide, please. So we have a registered right, we hold a title, and how can we enforce this right? To have success, it is necessary to prepare a strategy and analyze each particularities of each jurisdiction. Is it possible to enforce industrial rights against any type of products or class? For example, in the case of Mexico and Chile, enforcement is restricted to the same products, while in Brazil, Colombia, and Peru, enforcement against any type of products is allowed. We should also evaluate the measures and remedies that each country provides. In this sense, we should analyze which are the rights that are granted through designs. What can I prevent? Can I prevent third parties from making, from selling, from importing infringing products? Which injunctions are available? Which evidence should I prepare and provide to the court? For example, in the case of Chile, no testimonial evidence is allowed, only documental evidence, etc. Which defenses can we expect? The annulment of the registration, the lack of novelty, the lack of substantial examination, etc. We should also evaluate how damages will be calculated and compensated. Are punitive damages available? Only actual damages? Am I allowed to send a cease and desist letter warning the infringer of my rights, reserving rights to proceed in the future against him in a future trial, etc.? And as I said in the previous slide, we should also analyze the possibility of initiating actions before customs to prevent the entry of these products. As I said, not all countries allow custom actions in the case of designs. We have this possibility in Brazil, Venezuela, and Colombia. Particularly in Colombia, we have had success in those cases where it is possible to indicate that the merchandise is linked to a crime, and then through that way, the product will be prohibited to enter to the country. We have had successful experience with headphones and with smartwatches. Next slide, please. In this sense, we would like to share with you this practical example that took place in Colombia, which is very clear. The columns in the left show the designs that a client had registered, and the columns in the right show the actual infringing products. As you can see, there is no use of registered trademarks, so there is no trademark infringement. However, as this client had these several designs registered in different sites from different angles, and covering also the screen, the the back and the front of the watch, of the body of the watch, the band, etc., it was easy for custom to detect that this was an infringing product that infringed designs, even though no trademark was used. So this is something that we wanted to highlight because it's very clear for us how this is useful and how it can be used by our clients. Next slide, please. So now we will talk about preliminary injunctions. As provided by TRIPS, local authorities shall have the power to order prompt and effective provisional measures to prevent infringement and also to prevent the entry of infringing goods to their particular jurisdictions. These measures can be adopted in those cases where any delay is likely to cause an irreparable harm to the right holder, or where there is a demonstrable risk of evidence to be destroyed. To that end, authorities should have certainty as to the fact of who is the title holder, what is registered, and evidence of the infringement. These examples in this chart show what you can obtain by requesting and obtaining the grant of a preliminary injunctions in our countries. It's relevant to highlight that in all our countries, it is possible to obtain the cease of the infringement, also the seizure of the products. In all of the countries, it is possible to suspend the import or export of the products, to obtain warranties from the infringer, to obtain the temporary closure of establishments. And I would like to also include that in the case of Chile, my country, it is also possible to obtain the prohibition of advertisement or promotion of the infringing goods. So I think this is my last slide, and I pass now to Marina again. Thank you.
Thank you, Valentina. So regarding damages, as Valentina mentioned briefly, in most of the LATAM countries, it's really very difficult to estimate damages and also to prove damages, because you have to prove the IP holder has to prove the damages that they are suffering, like by filing, for example, sales balances to show a decrease due to the infringing product or to demonstrate the sales of the infringing product. So you have to prove it. And in countries like Chile and Brazil, for example, you may choose the most favorable method among the following to claim damages. No, you can, for example, show the benefits that the IP holder have gained if the infringer had not occurred, or for example, benefits or profits obtained by the IP infringer, or even the amount due by the infringer to the IP holder under an hypothetical licensing. In addition, in Brazil, for example, the plaintiff normally claims compensation for all losses and damages. In the case of Mexico, for example, it's the same. You have to prove direct damage and to file the evidence. However, the law states that compensation may not be less than 40% of the value of the products. And it can be the value of the infringing products or even the utility loss of the IP holder because of the infringement. And in Mexico, for example, you can claim damages before the Mexican Patent Office directly once you have a final decision of the infringement, or you can even go directly to civil courts without having a decision of infringement. However, if the validity of the design was challenged, you cannot continue the civil proceeding. You have to wait until receive the decision of the nullity action before the Mexican Patent Office before you continue with this litigation, but it's possible. In the case of Peru, for example, you have to claim damages directly before civil courts. And Finally, as Valentina also mentioned, regarding Chile, it's very interesting because they have a new law that will enter into force next year. So the new law mentioned a lump sum compensation for damages. So it will be like very interesting for LATAM, but they are still waiting for the regulations just to see how it will be regulated or how it will work. But at least it's important to know that it will be a bit different, Chile, with respect to the other countries in terms of claim damages. So that's all with respect to damages. So now Marcela will explain us also about the courts in each country.
Thank you, Marina. Well, again, different countries, different systems. As Marina was mentioning, in Mexico, you can request damages before the Mexican Patent Office. We have also the case of Peru, where you can file the case, the infringement case, before the Patent Office. And also claim before civil courts, but they would normally go to the Patent Office first because it's faster and it's better, as I hear. And you have other countries where you need to go to the court system directly, and sometimes with no specialization at all, like Argentina, Chile, and Venezuela. So you would go to a normal court, and the judge may not have even any expertise to analyze your claim. In other countries like Brazil, Colombia, and Mexico, you do have specialized courts. In Brazil, you have specialized courts in the state level and in the federal level. We have a bifurcated system in Brazil, so invalidity claims would go to the federal courts, infringement claims would go to state courts, and there are lots of interest repercussions between an invalidity case and an infringement case happening at the same time in this bifurcated system, because invalidity can also be raised as a defense before state courts together with the invalidity claim before federal courts. So you may, for instance, stay the infringement proceeding while you discuss invalidity or not, depending on the case. Designs, for instance, if the invalidity is an ex officio, for instance, invalidity from the patent office, it's the effects of the designs are suspended immediately. You don't even need to have any decision from courts. It's a suspension of the effects of the designs. But if it's a third party bringing an invalidity case, not necessarily. So you may need to request a suspension of the infringement case pending the invalidity, or defend from it if you are the design holder. And the case law is very controverted, depending on whether an injunction had been granted or not, depending on the timing of the filing of the two cases. So for instance, normally the case law will say that if the invalidity case is filed before the infringement case, you can suspend the infringement case. But if it's after, then you can't. And this is because you don't want to give the infringer this power to really suspend the infringement claim whenever he wants. And the case law is really going through this direction. I think this is all I wanted to say about specialized courts in the different countries. And I think I will now open and give the word back to Juan Pablo to answer any questions that we may have from the audience. And I invite you all to please make your questions using the Q&A button. Thank you.
Okay. Thank you, Marcela, and thank you all for your presentations. They have been very, very illustrative, and it looks like you have done the work. Thank you all for your time. Yes, I encourage everybody to send your questions, and yes, we do have one question, which is a very long question, and thank you for it. It says, so if a right holder sues for damages and injunctions, at the state level. So I think this is for Marcela. And you answered the lawsuit by requesting the annulment of the industrial designs. Does that move the case to the federal court, or the state case remains on hold until the decision is made?
Thank you. Thank you for the question and for the opportunity to answer that in a more detailed way. It's an interesting scenario. And because we have a bifurcated system, the infringement case will not move to federal courts. What will happen is if you raise an invalidity defense before state courts, the state court can analyze that, but with inter partes effects. It will not invalidate the design to everyone. We called, there will only be an inter partes effect and not an erga omnes effect. So if you want to invalidate the design from filing date, you will need to file an invalidity case before federal courts and include the PTO as a defendant, and then you may have that. There's some controversy on whether you can and the judge can really analyze invalidity arguments before state courts, especially in the patent cases. But normally the law is quite clear that you may raise invalidity as a defense. So the judge will of course be able to analyze that also before state courts. I hope to have answered the question. Thank you.
Okay. Thank you, Marcela. What will happen if the same situation happens in Mexico, Marina? Is there any defense? Is it a possible defense to file the annulment of the industrial designs?
Yes, of course. Well, now we have a new law that entered into force this year. So now for the first time, you can claim damages directly through the Mexican Patent Office, or you can go to the civil courts to claim damages. So if you go to the Mexican Patent Office, first you have to obtain an infringement decision that has to be final, and then you request INPI to state the damages that have to be paid. It's something new, so it will be very interesting to see how they will regulate this. And the other option is go directly to the civil courts, and you can go to the court without having an infringement decision. The issue here is that if there is a challenge of the design, which is possible, it has to be filed before the Mexican Patent Office. And once it's filed, the civil proceeding has to be suspended until the decision is made by INPI. So at the end, we will have the same scenario. No? If there is an invalidity challenge, we will have to wait until the final decision to continue with the damages claim. And all the proceeding is federal.
I can tell you that in Colombia, preliminary injunctions are available. Preliminary injunctions is a feasible option, but if somebody requests the annulment of the industrial designs, that will definitely be handled by the Supreme Court for Administrative Matters, which is the Consejo de Estado, the Council of State. A process within the Council of State could last between 8 and 10 years. So your process, your infringement process will be suspended until the Council of State may issue a decision in 8 years, which will be a complete mess, and it will be suspended for a long time, and it would not be a good option to go with the Council of State. Valentina, how about Chile? Is it possible to request for the annulment of the industrial designs in case somebody files an infringement of the industrials protected in Chile?
It is indeed possible. However, as in the case of Mexico, damages an infringement will be handled by an ordinary court, but the invalidity of the design registration will be handled by the patent office. So the civil procedure will have to be suspended until a decision is made in regards with the validity of the right.
Okay. Okay. Does anybody else have a question? If not, I will. Okay. Okay. If not, I will simply wrap up saying, yes, you have seen the difficulties of having different jurisdictions. You have seen the difficulties of having different laws. But the good news is that despite all these difficulties, we have the appropriate resources. We have the appropriate personnel attending these kind of things. As you've seen, we have special people, professionals with knowledge on this special topic, and we can help you navigate over the protection and the enforcement of industrial designs. This is a vibrant topic. Is a vibrant topic because of we have seen various multiple examples of unprotected designs. And if your organization is looking to enforce those designs, which is the best course of action, we certainly encourage you to obtain the protection, the adequate protection in the region. So I think if any of the panelists would like to say anything else, I think we are ready. And we thank you all for your participation. Yes, Marina?
I think there are two questions there. One is if it's possible to obtain interim relief in the meantime. And also another question from Marcela, if in the countries with an automatic registration system, do the registration have the same power? That I think it's also very interesting to comment.
Okay.
So Marcela.
No, go ahead, Marina. I can comment the second one.
Okay, regarding the interim relief, yes, in Mexico at least, during the infringement proceeding, you can obtain preliminary injunctions. You have to file a bond just to guarantee possible damages and also to show that there is a possibility of infringement. So you can do it. However, the infringer or the possible infringer can pose a counter bond to release the measures, but the decision will depend on the Mexican Patent Office if they grant or not the release of the measures, but of course it's possible. And regarding the second questions, we don't have an unregistered design, so maybe Marcela can comment on that.
Sure. So as I understood the question, the question is whether if there is any nuance regarding the reliability of a registered design in countries where you don't have substantial examination. So it's a very interesting question, and I do think it makes a difference when you don't have substantial examination. It's an very easy argument for the defendant to make, is that this is a kind of an empty registration because no one looked at that. No one evaluated substantially whether it fits the requirements or not. So for the defendant, I think it's an easy argument, and that happens in Brazil a lot. But what I can say is that even so, it's worth doing, even in countries where you don't have the substantial examination, because for instance, for notice letters, cease and desist letters, for customs, for other authorities, and even for a preliminary injunction, ex parte, when you have a stamp and a registration from a patent office, this gives you already some it raises the burden of the defendant or before the customs authority, or even to respond a cease and desist letter saying, oh, there's no substantial examination in your country, and that therefore no one looked at that, and I think this should never be granted. So it raises the bar, And I do think it's a valid strategy to go for it, even in countries where there's no substantive examination. I would even say that in countries where there's no substantive examination, it's even more advisable to do, because it's most cost effective, it's easier, it's quicker, and you can have an additional protection with that. And you can use, just going into details on strategy, you could use, for instance, a registration issued by a country with substantial examination to help you here. So for instance, if you have a litigation in Brazil and a defendant comes with the argument, but you see that there was a registration issued in Mexico, you can use that to strengthen your position in Brazil.
In the case of Chile, preliminary injunctions are possible to be requested and granted during the enforcement action. However, as we only have ordinary courts hearing this type of proceedings, they are very difficult to be granted. And in regards with the second question, we now have a substantive examination procedure. Next year, with the new law, we will have an alternative procedure of deposit only. But in case, as Marcela said in the presentation, in case the title holders wants to file an infringement action, it has to undergo substantive examination. So in this case, the deposit, the registration without substantive examination will not have the same power than the substantive examination designed.
Okay, I don't see any more questions, but in any case, if anybody has more questions, please feel free to let us know, send us an email, and we will respond to you as soon as possible, and we will be very glad to respond to any other questions. Okay, so I find this very useful. Thank you so much, everybody, for your participation. The clients that participated, we thank you very much for your time. And you've seen that we have really experts and professionals handling this kind of topics. So without any further ado, thank you so much, and happy to answer to any of your questions. Bye-bye.